over to you, Maria, to talk about the practicalities around using this type of thing.
So as Chris said, I've been asked on behalf of IPSEA to just talk about our experience of supporting parents, advising parents to use legislation and guidance to make a difference to children and young people with special education needs and or disabilities. If anyone, in case anybody doesn't know, that's what IPSEA is about. We provide advice and information, legally based advice and information on that subject. So that's what I'm going to be covering today. I'm focusing on SEN and the statutory, the statute and the guidance that relates to that. Of course, there's lots of other statute and guidance that might be relevant to people here today, but that's what I'm going to be focusing on. And obviously some of this, some of the things I'm going to talk about now, Steve will have mentioned or in passing. Our primary source of legislation when we're advising parents and carers of children and young people with special educational needs is the Children and Families Act. So that was the piece of legislation that came in September 2014 and quite radically changed the framework for the identification, the assessment and the provision for children and young people with special educational needs. Not least because it extended the framework beyond the age of 19 to 25. So there are now young people with special educational needs that local authorities may well have duties to because of the Children and Families Act. It was this piece of legislation as well that introduced EHC needs assessments, education, health and care needs assessments, and education, health and care plans. So obviously, if any of you here today have children and beyond, under the age of 25, you may well be familiar with those. You probably will be. You may have children who have EHC plans, and some of you here today who perhaps are parents of adults or who are adults themselves, you may be familiar with statements of special educational needs. There was the Children and Families Act that brought sort of statements of SEN to an end and introduced EHC plans. And then sitting underneath the Children and Families Act, our primary legislation, we have a set of regulations. There are some other regulations. For example, there are some regulations dealing with personal budgets, but the primary regulations, the ones that we refer parents to a lot, are this 2014 SEN regulations. These are the regulations that provide the fine detail, the nitty-gritty detail in terms of local authorities' duties. They're particularly useful and important because they deal with timescales, which obviously are very important to be adhered to, and they provide lots of other detail, for example, in terms of how annual reviews need to be conducted, that sort of thing. And then the last item on that list there is the statutory guidance that's most relevant for people advising parents, children with SEN, and that's the SEN Code of Practice. So statutory guidance, which local authorities and various other bodies, including schools and FE colleges, must have regard to. And Steve has already helpfully explained the concept of needing to have regard to something. So that's the statutory guidance. The Act, the regs and the statutory guidance that I'm going to be referring to today, just really to illustrate to you how all of those various aspects of the framework can be used. So some examples of statutory duties. I've chosen some here that would be these are examples of statutory duties that we refer to very, very often. Unfortunately, we have to refer to them regularly because they're often breached. So local authority, these are quite common areas that we find local authorities do not meet, but nonetheless, it's obviously still really important to be aware of them. So first of all, we've got section 42. That's the duty on the local authority to secure the special educational provision that's in section F of an EHC plan. That's a really clear duty, providing the provisions in section F of the plan is clear, and of course that's often the problem, but if it is, then there is an absolute duty on the local authority to secure that. So that's a very clear, unambiguous duty, and it's one of the duties that we have developed. IPSEA has developed a model letter that parents can use if their local authority is in breach of that particular statutory duty. Then there's an example of something that we might use the regulations for. That's the requirement on the local authority to issue a final EHC plan within 20 weeks of the request for the EHC needs assessment. So that, again, it's a crucial duty. It's clear, it's unambiguous, that there can't be any, disagreement really as to whether the local authority will be in breach of that requirement or not. So again, we have a model letter actually that's available for parents, carers to use if that was the issue. And then I've just given a couple of examples of statutory duties that derive from the Children and Families Act that are relevant to education providers as opposed to local authorities. So we've got Section 67 duty on mainstream schools and nurseries to have a SEN code, and the Section 68 duty to inform a child's parent if special educational provision is being made for them. Again, I've just sort of chosen those particular examples because of the clear-cut nature of them and the sort of relative lack of ambiguity. Now, there are some statutory duties, however, that are more open to interpretation. So, for example, Section 19 of the Children and Families Act, which is where that's at the beginning of Part 3 of the Children and Families Act, which is the section of the Act that deals with identification, assessment and provision of children with SEND, says that local authorities must have regard to the views, wishes and feelings of the child or their parent or the young person, child and their parent or young person, Section 19A. So that's a statutory duty, but you could probably see from, by comparing that to the duties on the previous slides, that it's potentially open to interpretation. Then we've got the Section 66 duty, and this is one that Steve mentioned. This is what we call the best endeavours duty. It's a duty on schools, mainstream schools to use, and FE colleges to use its best endeavours to ensure that the special educational provision called for by a child or a pupil is made. It's best endeavours duty. And again, you can probably imagine that could be, without the benefit of guidance, perhaps more difficult to enforce. It might be more difficult to establish that somebody wasn't actually using their best endeavours. And then another example of a local authority duty here that's potentially open to interpretation. The local authority must carry out an EHC needs assessment if the child or young person has special educational needs and it may be necessary for special educational provision to be made for them. Of course, the very fact, well, as a result of the fact that the word necessary, as you can see it there, is open to interpretation. But for that reason, we have quite a significant body of case law from the upper tribunal that has provided guidance on when an EHC needs assessment may be necessary. Okay, so it's really where these statutory duties where they are open to interpretation and could be interpreted differently by different people. That's where the statutory guidance really helps us. So, for example, throughout the SEN Code of Practice, there are references to local authorities needing to have regard to the views and feelings of the child and their parent or the young person. So, if you did a sort of a search in the document for views or feelings, you'd see it coming up at different stages, different parts of the Code of Practice. So when that's because the code is saying that the local authority should, for example, consider in particular the views and feelings of the child, the parent or young person, when considering whether to carry out an assessment, when carrying out the assessment, and when consulting on a draft EHC plan. So the guidance helps us to know exactly when it is that local authorities are expected to have that regard. Another example of helpful sort of input from the Code of Practice is the paragraph referred to there, which tells us exactly when schools should consider involving specialists, which is where if a pupil continues to make less than expected progress despite evidence-based support and intervention. So that's useful, a useful indication of when a school should do that. Again, providing more guidance on the interpretation of the term necessary. As you recall on the slide before, I said then LA should carry out an EHC needs assessment if a child has or may have SEN and it may be necessary for provision to be made in accordance with the plan. And this aspect of the Code of Practice tells us that a local authority but it may be necessary for a local authority to assess if a child, even though a child has made progress, if that progress is the result of additional intervention and support that you wouldn't normally expect that child to have received. So that's really helpful guidance that a parent might be able to use. If their child has made progress and the local authority is saying, no, we don't think an EHC needs assessment is necessary, we don't think they'll need a plan. But if that child has only made progress because the school has been giving, I say, a much higher level of support, then the code tells us that that is a factor the local authority should be taking into consideration. And then lastly, on that slide, the code of practice helps us understand what's meant by meeting their best endeavours duty. So as you remember from the previous slide, section 66 of the Act, so there is a statutory duty that says schools must use their best endeavours. And then by looking at the code of practice and the description in the code of practice of SEN support and what that looks like, when the code goes into detail describing a 4-part cycle of action. If a school or setting wasn't following the guidance in the code and wasn't delivering SEN support in that way, then it would be likely that, that there could be an argument that the setting wasn't using its best endeavours. Okay, so that's some examples of how the statutory guidance helps us interpret statutory duties that might be ambiguous in some way. But we also have added benefits from the guidance. So the guidance sort of expands and fills out the requirements in the Act and the regulations. So for example, there's a section in the code that gives guidance on how a school or a setting should decide if a child does have special educational needs or not. And this is this paragraph from the code of practice is one I would say that we do regularly mention to parents whose child or children are making progress. Perhaps their school or the local authority says they're within age-related expectations, so they really don't need an EHC needs assessment, or they don't even need to be on SEN support. And the code of practice tells us that even for children whose attainment is in line with chronological age, that doesn't mean that there's no learning difficulty or disability. So that can be really useful, as say, for those children who perhaps are working or capable of working at age-related expectations, but who are struggling perhaps in terms of their social, emotional, mental health, or their independence. And the code of practice as well, it gives us, it has come up with 4 broad areas of special educational need, which again, so that's kind of adding to the information that we get from the Act and the regulations. It's got these 4 broad areas, one of which is social, emotional, mental health difficulties. And that's particularly helpful. Again, it's related to the previous point really, because quite often parents of children whose difficulties fall within that category are told that their child doesn't have special educational needs. So the fact that the code has identified social, emotional, mental health difficulties as one of those 4 broad areas is really helpful. And then one other one, which I threw in, because again, we quite often refer to this, the code of practice says that the evidence and advice submitted as part of an EHC needs assessment should be clear, accessible and specific. And unfortunately, that often is not the case, but a parent who's perhaps seeing the assessment reports that are being provided to the local authority as part of their child's EHC needs assessment, if they aren't detailed and they're vague and short on detail, this aspect of the guidance could be helpful for them to refer to. Okay, so there are limitations of statutory guidance, as Steve has already explained. It is to a degree subjective. It can be just because of the language and because it's not talking about black and white facts. It is subjective, which means it can be open to interpretation, and it can be difficult sometimes to demonstrate that a body isn't actually complying with the code of practice. It can't override statute, and that's a really important point, which Steve has already explained. The code of practice can't override statute, and connected to that, there could be statements. We know that there are statements within the SEN code of practice, for example, that have turned out to be incorrect. So even if a parent sees something of value in the code of practice, it's possible that it could turn out to be not reflecting the underlying statutory obligations, so it has limitations in that respect. And I've just got a couple of more slides, just in case people are concerned about the time. Just wanted to explain the different ways of enforcing SEN law. So if a body is in breach of a statutory duty, there are a number of options. First, it would be a matter or a question of a formal complaint to the body concerned. So for example, if it's the local authority who were in breach of their Section 42 duty to secure the provision in the plan, the first action would be a letter of complaint to the Director of Children's Services. If it was a school that was in breach, so the duty to admit a child if named in the plan, which was one that Steve mentioned, again it would be a formal complaint to start with. And as you can see, there's numerous IPSEA model letters there. A breach of statutory duty on the part of a local authority could be escalated by complaining to the local government and social care ombudsman. The ombudsman normally expects the body's complaints process to have been exhausted first, but that's another option. And there's always the option of asking the courts to review a decision, which we refer to as judicial review. So those are, as you can see, where there is a breach of statutory duty, the options for redress open to parents or young people are quite sturdy, I suppose, for want of a better word. However, if it's statutory guidance that's been breached, again, it could be a formal complaint. That would probably be the starting point, formal complaint. In the case of a complaint about a school, it could be a complaint to the DfE or Ofsted, could be appropriate. A complaint to the Ombudsman would only be likely to be possible if it was possible to show that there was actually maladministration that had taken place. So it would be very unlikely for the Ombudsman to investigate simply because the body concerned didn't appear to be following the statutory guidance. And the SEN Tribunal, which is another avenue open to parents in relation to certain decisions of the local authority that they disagree with, the SEN Tribunal will also take statutory guidance into account when, for example, looking at, for example, if it was an appeal about the contents of an EHC plan, that would be something that the tribunal would look at.